Thank you very much, Professor JánosBóka Szilágyi. Thank you all. I would like to thank also Timea Barzo and Katarzyna Zombori, and of course the Central European Academy and Central European Professors Network. Thank you very much. Today, and I would like to also thank Katrina that she actually gave me her place because I have some allergic issues and I'm kind of slow and sleepy. So my presentation today, I hope it won't be long, but I also hope it won't be boring. I will try to skip to the point. So I was thinking something about what would be interesting for you in connection to the rule of law, the legality, the criminal law, and some case law. So I was thinking about the topic of exploring the rule of law in Croatian criminal justice through the lens of the law on exemption. Law on exemption is a special law in Croatia, and I will be talking about it. It's kind of pandemic and actually endemic sort. And I had a big introduction, but don't worry, we won't deal with all of this. Something about the rule of law. I was thinking that the presenters who are preceding me that will say something about the rule of law. So unfortunately, I will have to say something in only 3 words about the rule of law, then the elements, principle of legality, similar experience, concluding remarks. So what is really actually the rule of law? Dear colleagues, dear professors, dear students, you all know actually what the rule of law is. It's the rule of law by the law, not by the people. And what does it mean? It means that in the principle, every person and entity is subject to the law, no matter and regardless of the social status, wealth, or power. It is also the foundation of democratic societies. And I will skip all of it, the UN definition, the Venice definition, but I will stop here. Why? Because you see there is a lot of it, 6 elements of the rule of law, and at the first place is legality, including transparent, accountable, democratic process of passing laws. In the European Court of Human Rights case law, legality encompasses both existence of the law and the quality of the law. And when we put that to the criminal law perspective, of the substantive criminal law perspective, you all know that legality means nullum crimen nulla pena sine lege, right? And nullum crimen nulla pena sine lege has its sub-principles. And this is something important I want to share with you because we had in Croatia, and this is something, this new case law, this new law and the case law, we call it, it's a very huge, I have to find, I know the name of the law. We call it law on exemption, but this is law on exemption of statute of limitation for war, profiteering, and process of privatization transformation. Oh my God, have you heard the law with such a big, huge name? So we call it law on exemption. But what actually happened? Well, actually happened that in during the war, you all know that Croatia was in a war, and the period was around, there is a different time frame, but from our encyclopedia was from the August 1990 to the January 1998. And one of our former prime minister, well, that former prime minister, he kind of liked doing criminal offenses, so he has 5 cases against him in only 13-year period of time. He really likes to do crimes. But one of those crimes was during the war in 1994 and 1995. This was the most famous case. And our state kind of decided in 2010 that lots of funds, lots of money went somewhere, and Croatia doesn't know where the money is. And they introduced, they wanted to introduce this new law, the law on exemption. But to do that, they had to change the constitution first. So in 2010, they amended the constitution in Article 31, which deals with the legality, and actually stated in paragraph 4 that for some criminal offenses which were committed during the war or during this privatization process, there is no statute of limitation. This sort of criminal offenses cannot be statute barred. But you can see here the issue. The war was, as I said, top 1998. The law was, the constitutional amendments were in 2010. And these constitutional amendments was the base for this law on exemption. And in 2011, they brought the law with actually retroactive application. Going aligned with that, we change, actually not change, we introduced, enacted a new criminal code in 2011. And we have also changed our provisions of the statute of limitations there. And what this law on exemption says, basically, that some sort of criminal offenses, let's say corruption criminal offenses, trading and influence, etc., will not be statute barred. You know what is statute barred? There is no statute of limitation for those offenses. If they have been committed during the war or privatization process. So privatization process is something that we can all go through and maybe still on, but war is over. However, they said that they enacted this law, and this law is valid. Not only valid, but is applied. This is a brief introduction. And now we have our case. Yes, our former prime minister. He, as I said, he has done a few criminal offenses. This is our most famous case. And regarding one case, and I can say now, Hypo Alpe Adria Bank, he was not the prime minister then, but he was deputy of Ministry of Internal Affairs or something like that. He actually got a bribe. That was in 1995. And that's why Hypo Alpe Adria Bank changed his name into the Addiko Group. That was one of the issues. But in that case, our former prime minister he was acquitted. He was not convicted. This case was joined with some other case, and I won't say the name. It is everything in the article, because our Hungarian friends could think that I have something against them, but I really don't. It's a case that exists. And it actually, they joined two cases, that Hypo case and that Ina case. And it doesn't have nothing to do with you, but it's a case. And what actually happened, this case, why I'm saying this, because this case went to the Constitutional Court. And Constitutional Court made a decision in 2015 and said, oh no, you cannot do this. You first have to determine whether this case, those criminal offenses have a new elements, because you cannot say that something in 2011 won't be statute bar if the general criminal offenses have a new elements, and if the general criminal offenses, the first one, if they are statute bar. If they are statute bar, this law cannot be implemented or applied to those sort of cases. So a huge amount of the cases actually won't be prosecuted toward this law. Why I'm saying this, to skip to the main point, this you can say not so strange or maybe not so relevant constitutional decision had a big impact to our judiciary. So what actually, there is also a Venice Commission standpoint in Kononov case. Also, our Hungarian friends had some similar issues in 1993, also about statute of limitation in 2013. Something about lustration measures also was some issues before. I don't know, correct me if I'm wrong. And what actually the Venice Commission said, that I would like to cite that provisions regulating this must, this is from this other, from 2013, that the provisions in constitutional amendment regarding non-obvious or non-statute barred nature of even inhuman crimes committed against the Hungarian people during socialist and communist dictatorship, this is a citation, is deemed unacceptable. Not deemed unacceptable, there is some explanation there. It must conclude that provisions regulating this must at least allow for sufficient flexibility with regard to proportionality, taking into account the individual circumstances of each concrete case. Actually, they say that something, when it's so long, when there is so long period of time, and when we are going back in time, it's not in line with the rule of law. And this is not acceptable. So, to skip to the point, now in Croatia, we have situation where we have a law, a living law, let's say, and we have a constitutional court decision which says, oh no, if the criminal offenses are statute-bearer, then it cannot be applied. So what happens? The prosecutors, they initiate proceedings for by this law, for lots of criminal offenses, even those who are statute bar, then that it goes to the courts, and the courts actually gives a negative decision, dismiss the case or gives acquittal. So I wanted to show you data in brief. I cannot find, never mind. I know it by heart. In 2022, we didn't have any case by proceedings by these law and exemptions. In 2021, we had 3 proceedings, and all of 3 of them were dismissed. In 2020, we had 5 proceedings. 3 were dismissed, and 2 are still waiting for the second court decision, which is most probably and high likely will be negative. So actually, we have only cost, not we haven't reimbursed any funds. What was the initial idea of this law? So the opinion of the Venice Commission was, concluding remarks, that law and exemption actually enables the retroactive prosecution of specific crimes with privatization and ownership transformation and war profiteering from the 90s. It goes actually against the principle of legality, but I have to state something here. The principle of legality is a principle of substantive criminal law. It's not of the procedural one. So what is the core, the crux of the matter, the cornerstone is the nature of statute of limitation. So the countries which have a statute of limitation in criminal procedural code, they can actually apply this idea because principle of legality does not apply. Countries which do not, which regard statute of limitation of substantial nature or mixed nature, they must apply principle of legality. And Croatia, it has the statute of limitation of mixed nature, therefore it must apply a principle of legality and prohibition of retroactivity, and this law actually is not in line with that. Also, something what has been committed 21 to 29 years ago through delayed administration of justice actually leads to injustice. And further support by the Venice Commission concluded the case, also illustration in Hungary, with that delay implementation of law and justice due to significant passage of time has the opposite effects and violates actually the principle of fairness and the principle of rule of law. So congratulations to Hungary. They didn't follow the path that we have. We have really endemic situation, I think, in the whole world. Thank you very much for your attention, and I hope this was not so boring, because I really don't have strength to be like usual very enthusiastic. Thank you very much.